In this video, we will discuss the relationship between discovery and pleading requirements in the United States. Discovery is the process by which parties to a case obtain and disclose evidence related to the case. Two important features of discovery in the United States are that discovery is exceptionally broad and also largely controlled by the attorneys and by the parties without the involvement of the judge. It is also important to remember that in the United States, it is usually easy to start a civil litigation. In federal court, we just need a short and plain statement of the claim, plausible allegations, and there is no need for evidence or for proof. Because pleading requirements are lax, at the beginning of the case, the parties are likely to have little shared information or evidence. But that would be a problem because eventually we need to have a trial. A party can't effectively defend himself at trial if he doesn't know what the facts of the case are supposed to be. A plaintiff might not be able to prove her case if she doesn't have access to all the relevant evidence. And jury members cannot reach a rational verdict if they aren't presented with a complete set of facts and evidence. Discovery is meant to provide the missing facts and information prior to trial. In the United States, during discovery, parties are expected to disclose all relevant or even potentially relevant evidence prior to trial. As an example, let's say we have a plaintiff, Patty, and a defendant, David. And we'll say that in her complaint, Patty alleges that David breached a contract. And the allegations in her complaint are David failed to deliver 1,000 flowers as promised. Patty alleges that instead of sending 1,000 flowers, David only sent 500. In David's answer, he simply denies that he breached the contract. And he raises an affirmative defense that Patty and David modified the contract and agreed that David only had to deliver 500 flowers. So the issue in this case is, did David breach the contract by delivering 500 flowers? But how can we know? The complaint, the answer, and the affirmative defense don't give us the necessary evidence. We need evidence to know which side is right. To decide which side is right, we would want to look at documentary evidence and hear from witnesses. During discovery, both parties should disclose all the evidence relevant to the claims and defenses in the action. For example, David can demand that Patty show him her documents related to the contract. It would help David if he learned that Patty sent an email to her colleagues saying, "We agreed that David would only send 500 flowers." Of course, Patty will also have an opportunity to look at David's documents related to the contract. Through discovery, prior to trial, both parties have access to all the evidence relevant to the case. If you'd like to discuss discovery or any other matter related to U.S. law, stop by the message board and please visit my blog. Also, feel free to send me an email and to submit your comments below.